Yeah, good mornings, guys, or the famous good mornings, guys, as my enemies like to portray it. Yeah, interesting day that we're going to have today. Let me just wait. Okay, and we've got 100 people up. Okay, after my video yesterday about the Theresa Mulderij and Gold Rush group, now we know the media sits on my page and they follow me for everything that I do, but unfortunately they simply do not have the balls to give me time on their pages, um, or for that matter on television. But anyways, since my broadcast yesterday relating to the Mulderij and Gold Rush case, the media has now lit up, and you have the most curious and the most strange versions coming out of what happened at CCMA. The CCMA now all of a sudden is also now a court of law. The CCMA is not a court of law, and how a sacked employee was denied legal aid, and I don't know what. I see on a certain group, actually a very big group, Legal Talk or Legal Aid South Africa, Legal Talk South Africa, what. It's discussed this morning that there's a legal loophole to dismiss employees. No, there's not. Um, what's interesting to me, some of the supposed very well-versed attorneys, and I say this really with no disregard or disrespect to the real profession. Guys, I speak of the little group trying to slander me, and pro-vax element trying to put their point of view across. They also had a discussion this morning. And I was very curious. Now, in the first place, they also referred to Theresa Mulderij losing a case in a court. And then one of the clever ones there says, but surely this can be fought in the constitutional court. And then the other one goes and she wiki what happens after CCMA, and all of a sudden they realize the case is not going to constitutional court, it's just simply going up for review to the Labour Court. Okay, let's educate the educated. And this is really not for real attorneys, real advocates doing real cases in the real world and knowing real law. This is for the CCMA is not a court of law, Marlene Lawrence. Even you, and I'm saying this with the greatest respect to you as a layperson in law, knows these things. Okay, so let's educate these educated lawyers sitting out there. I see everybody calling themselves lawyers, attorneys calling themselves lawyers, has something to say about this. Okay, what happens in the legal process relating to labor law? If you have a dispute, you declare your dispute usually internally. Now, it can take two forms. If it comes from the employer, it ends up with the procedures as described in the Labour Relations Act, and more specifically, Schedule 8 to the Labour Relations Act. In other words, if you have a dispute with your employee, you say to the employee, you did this or that or the following wrong, then you will have to follow the procedures as set out in law. Okay. The employee usually has the opportunity to lodge a grievance inside the workplace. However, most often these disputes are not resolved in the workplace, and it can lead up to where, in this instance, I still don't understand what happened, but apparently a hearing was held, and then Mrs. Mulderij was dismissed for being permanently disabled although she does not have any illness, or she did not do her work. And then it goes to the CCMA. Now, the CCMA is not a court of law. It is what is called a creature of statute. There is specific legislation that creates the CCMA as an arbitration or mediation or conciliation forum. It's not a court of law. It's a mediation or arbitration forum, where the parties then go and the dispute is first conciliated. In this instance, there's other routes that can be followed at CCMA, but this one is a dismissal dispute, so it was conciliated. Now, conciliation simply means that the CCMA tries to bring the two parties together and to a possible settlement, and that is where I have reported so often on. That is usually where the cases where I'm involved in dies, because the employers realize they don't have a case and they settle. But in this instance, there was not a settlement. I gather from the award itself, I read it, that Mrs. Mulderij was not represented. She was there on her own, and she faced the full legal team of Culturas Group, which in itself is not very clever. With the greatest respect to the applicant, if you fight a case of this magnitude and with such implications, I do not advise anybody to go onto that battlefield not with at least a well-qualified union official. I would have supposed in this case that you would at least would have had to have your attorney or your advocate with you. Be it as it may, after the CCMA then makes a decision, and that decision is called an award. That award can be reviewed in Labour Court. Now, that is not something new or strange or out of the ordinary. In fact, most cases that ends up in awards and ends up in an arbitration and it's adjudicated by CCMA. And now, Ibn Potgieter, you must listen to me. Those cases are not seen as finalized by the CCMA, and they are then usually reviewed in Labour Court. Labour Court is a court of law. It's in fact a high court of law. It's also a creature of statute, but it is endowed with the authority and powers of a high court. If the case is then still in dispute after a review by the Labour Court, and I will get back to what the processes are, it can then be sent on appeal to the Labour Appeals Court, which is a proper appeals court with the same level and authority of law as the ordinary appeals court down in Bloemfontein. If there is still something outstanding relating to a constitutional issue, which you sometimes have in these cases, it can then also be referred to the ordinary constitutional court in Johannesburg. So now is Sonia Snell sitting on your Facebook asking, is this case now going to the constitutional court? No, it's just going to be reviewed in the Labour Court. There's also not a precedent set. As I explained yesterday in my first video, the CCMA commissioner does not create a precedent, although other commissioners, if they differ from the awards of a commissioner, and they may, there's not a problem with that, they must just then simply state why they do it and give a reason in their award to say, I disagree respectfully with Commissioner X, Y, or Z, and these are the reasons, and this is why I come to a different conclusion. Okay, there's no precedent set. The precedent will only be set once we have finality, for instance, in a Labour Appeals Court, one day, 5 or 6 or 10 years from now. Yes, you heard me right. You heard me right. Okay, what is a review? A review is a process in the Labour Court where the party that feels aggrieved, it can be the employer or the employee, where they differ from what the commissioner found, then take this case on review. It is not an appeal to the the higher court, it is, or the labour court, it's a review process. In other words, the processes inside the arbitration is investigated by the labour court, and they then make a finding whether they agree or disagree with what the commissioner said. And if they disagree, they can do a couple of things. One of them is they can substitute his award with a finding of the court, and sometimes they can even send the case, just simply send it back to CCMA to be re-arbitrated by another commissioner. Okay, nothing strange. There are literally hundreds of cases referred for review every year. Why did I mention a certain person by the name of Ibn Potgieter? Previously, Ibn Potgieter mocked me to say, but Schalk, we don't understand what you are saying. You're saying that you win cases at CCMA, but all those cases are settled. Yes, because a settled case at CCMA is finalized. If a case is settled at conciliation or during the arbitration, the parties come to the conclusion it's a better option just simply to stop the proceedings and settle the matter there under the auspices of the CCMA. It is a full and final settlement of all and any disputes between the parties, relating, of course, to labour law, civil law, criminal law. Those things are for other jurisdictions. Okay. Then the case is finalized. The CCMA archives that specific file, and it's closed on their system as a finalized matter. If a case goes to arbitration, it is not seen as a finalized case. Even if there's an award, the case is not seen as finalized. Why? Because it can be reviewed in labour court. And this is exactly what we are sitting here with. With the greatest respect to the commissioner who adjudicated this case, I read the award once again yesterday evening. Very strange award. In the first place, he speaks of a hearing that was held, one hearing that was held, where the employee was then found to be permanently incapacitated. Now, firstly, you do not do hearings in capacity cases. It's a process that is followed. Where an investigation is lodged, then there are certain parameters set for a worker, and a time is given for the worker then to respond back. It's usually a couple of weeks and so forth. A whole process is followed in the event of incapacity. We discussed that also in great detail in an earlier video of mine, when we became aware of what the big companies are trying to do in this case. Secondly, a hearing envisaged that we were sitting with a disciplinary matter. Now, you can never be ill-disciplined and then in the same process also be incapacitated. I mean, it speaks for itself. It's two different processes. So it seems to me that the commissioner, with the greatest respect once again, did not in the first place even understand what process was followed by the employer. The wrong process for dismissal was used. You can't have a disciplinary hearing or /hearing and then find a worker incapacitated in the workplace. Right. Secondly, we are dealing with the whole issue of permanent incapacity. Now, the commissioner can't make up his mind whether this relates to the employee not being able to perform her duties, which would simply constitute, to his mind, to his argument, incapacity to perform work, which can relate to anything right through from ill discipline to just simply the employee not meeting standards, which is not the case here, because the other party also says that there's no problem with her work. And secondly, he can then decide whether it's the second form of incapacity, which is totally different from the first. He even cites the learned Judge van Niekerk in his writings, where van Niekerk, Judge van Niekerk comes to the correct conclusion, respectfully so, and I have great respect for the learned judge, that there's two kinds of incapacity, the one simply relating to the worker's capacity to do his work, and secondly, illness. or injury. And then the commissioner even confuses himself as to that. He mixes up the two. And then he comes to the strange conclusion that this worker is now permanently incapacitated. But she has no illness, and she did not fail in her duties. Right. So this award, media, was already made on the 21st. You're sitting on my page, and yesterday, only yesterday when I made it public, I made a video about this. Did you, News 24, Business Tech, you guys, you started to report on this. My problem with this is the following. Why are you reporting this thing askew? You run to some obscure, I don't know, consultant, for an opinion. He doesn't understand what's going on. He also gives you the wrong opinions, and you publish it. And now you try to create the impression in the media that there is now a precedent set, and employers can run around unbridled and dismiss the employees for permanent incapacity because they have not vaccinated. Let me be straightforward with you. It's just simply, number one, disingenuous. Number two, it's simply stupid. And thirdly, it's highly irresponsible. Because after my video, I started to receive outcomes of exemptions galore from employers all of a sudden. That exemptions are now not successful. And I'm very sure today I will be overflowed by employees now waking up and coming to Schalk for assistance because the exemptions today, on the back of this, will now not be successful. It's going to be quite a hectic 2 or 3 days, I suppose. Why? Because we're going to see a huge amount of dismissals on the back of this by employers just simply reading the news and reading the media, because the media is what informs them, not law, not lawyers, proper, real lawyers. They listen to the media, and therefore they end up in the end with greater problems than they have. I'm still looking for Mrs. Theresa Mulderij. Please come into contact with me. I want to take your case. For those people out there already saying, oh, but Schalk spoke about it, he's going to make money off it. Let me give me my personal undertaking. There will be legal costs. In any case, there is legal costs, right? Nothing to do with representation, with the attorney, with the advocate. All legal cases have costs involved. I will not charge 1 cent for any service I render in a case like this. So Theresa, in your case, you can bring it to me. I will not charge you anything. I cannot tell you that the instructing attorney, or if we use an outside advocate, is not going to charge you a fee, but I will not charge you anything. Okay? So sorry if I burst a few balloons now. I'm not here to make money out of this. I'm here to serve my people and to stop this craziness. That's my objective. Okay? So the long and short of the Mulderij and Gold Rush Group case, please, Theresa, you will have to take that case on review. It's a very simple process. It's actually a very easy process. And I think we can pretty much say with great certainty that you will most probably win that case at Labour Court. With the greatest respect once again, and I say this in respect to the Commissioner erred, and he erred grossly in his decision. He goes as far as to say, I relied on the opinion that was published also somewhere in the media. It's not a court case of a judge, and therefore I come to a conclusion, but it doesn't contextualize even what the judge said, because he only read the little piece, the one paragraph that the media published of what that judge said. Okay. He was misinformed, he was misadvised, and with the greatest respect to that commissioner, I don't think that he even understands the basics of dismissal law relating to incapacity. If there's not a doctor's report, and usually there's a second opinion, and usually there's a report by the district surgeon, the state's doctor in other words, that a person is permanently incapacitated to perform duties, you cannot decide it. You are not an expert of the medical profession. Relating to the issue at hand, the issue that was raised by Theresa Mulderij was that her constitutional rights were infringed upon. Mr. Commissioner, with the greatest respect, can you even adjudicate a case like that? Can you even make a finding on a constitutional matter? Respectfully, no, you cannot. You erred, and you erred grossly. And therefore this case will need to go on review to Labour Court. It doesn't influence any of the cases at this point in time on the roll. It doesn't influence any of the cases that most probably will end up on the roll, of which there are hundreds upon hundreds upon hundreds that I know of. But unfortunately, we're sitting with this half-baked, with the greatest respect, award now, after you listened to my video yesterday, media, that you're reporting on, and you don't even understand what's going on. You don't understand law. You don't have a legal expert to tell you, go to Schedule 8 of the Labour Relations Act. Go specifically to the sections dealing with incapacity. Go and read it for yourself. It's there. It's not what Schalk from Merwe is saying, it's what the legislature said way back in 1995, 94, if I remember correctly. When it was discussed, it was a white paper and it came through as legislation in 1996. The intent of the legislature as the elected representatives of the nation of South Africa simply did not envisage what happened in this arbitration decades later. So please go to the Labour Relations Act, Schedule 8, and go and read what incapacity is and what the employer was actually supposed to have done. Then go and read Section 192, subsection 2 of the Labour Relations Act, and go and see what the employer was supposed to come and prove, which did not happen. And then you will understand why this finding, this award by this commissioner is grossly erroneous, and it's ready to review. You will draft these papers in half a day. Okay? So Theresa, please come forward. It's not going to have to be public, but we need to take this case on review and make sure that justice is served in this instance. Okay. Right. Let's see what today holds. I'm going to be very busy. I have quite a few clients to attend to. Maybe I will not be back on Facebook today. I hope to be, because there's some other big news coming. So media, you have to sit on my page because you're not going to hear it otherwise. I hope to hear it still today. But for now, I'm signing off. And yes, maybe later on today, I will see you again.